If a revocable living trust is opening up a trust bank account, does it need an EIN? The short answer is typically no. But it is an extremely common question, as people have either heard of an EIN or they're somewhat familiar with it, as they have a business, a corporation, or an LLC, and they have to get an EIN to open up a bank account for their business and file taxes under that EIN. Now in this case, I understand the confusion, especially if you've never dealt with trust before, let alone opening up a bank account for one. Let's address when a trust needs an EIN and what are some of the ramifications if we get an EIN a little prematurely. Thank you very much for watching. Please be sure to like the video, subscribe, and without further ado, let's dive in. Now, let's start talking about your own revocable living trust, as in you're still able to amend or completely revoke that trust. If that's the case, then it shouldn't need its own separate EIN to begin with. The EIN, also called a TIN or trust ID number, for a trust that remains revocable as the trustor and settlor are still alive, well, that's going to be the trustor or settlor's personal social security number. This is because from a tax perspective, both the IRS and the FTB for California, they disregard the existence of the revocable living trust. It's a disregarded entity. They don't care you have a trust, they don't want to know about it, they just want you to continue to file your taxes as normal. If you acquire an EIN for your trust that is still revocable, something you technically can do, then you'll need to file a separate return for the money that that trust earns. The IRS will come knocking for that tax return. So the question then becomes, what's the tax impact of doing it this way? Well, nothing much. The IRS will still ask for the 1041, that's the trust tax return, but it would likely be a blank return, as in all income is reported to you personally. Your accountant might charge a little extra to put the form together, and the IRS might assess a minimum tax no matter what. But the point is, even if you have an EIN for your revocable living trust, from a tax perspective, the earnings that that trust has are still taxable to you personally, and thus the IRS wants all those taxes reported on your personal tax return. But the fact that you have an EIN means the IRS also wants to know what's going on with that trust. They want a tax return tied to that EIN, even if it's a zero return at the end of the day. Moral of the story, don't complicate the narrative and get an EIN prematurely. All it does is create more work for you, more work for your accountant, and I suppose more work for the IRS agent, but in their perspective, probably doesn't matter. At the end of the day, in order to keep your sanity, don't get an EIN when you don't have to. But that then leads us to, what about a trust administration? What do we do with the trust where the trustor, the settlor, the person who made the trust, has now passed away? Well, in the overwhelming majority of cases, yes, an EIN is required, as that trust is going to be collecting money and therefore needs a trust bank account open. The trustor, settlor, the person who made the trust, is now deceased, so we can no longer report any activity on their personal return. Thus, we need a trust with an EIN to file a tax return under for all the activity that occurs in the deceased person's estate after they pass away. As a little side note, we would need an EIN for their estate to open an estate bank account, but that's a topic for its own discussion. Here, we're assuming there's a trust in the mix, no probates required, so we're all working under the trust estate. Now, even if you were to try to forego getting an EIN, try to skip over that step, you're going to get your first roadblock at the bank itself. The bank is going to require that EIN confirmation letter from the IRS, along with a copy of the trust, a copy of the death certificate for the person whose trust we're administering, and of course some photo identification for you, being the trustee. The bank is going to need to have all of those things on hand in order to even open up that bank account in order to begin collecting money. So if there's any money involved in a trust administration, you're going to need an EIN. But what if the trust estate has no money? Only personal property, or more likely, only some real estate? Well, during the administration process, if we're going to be selling the property from the trust, then yes, an EIN is needed to open a trust account to then receive the sales proceeds from the sale of the property. Plus, now that that house was sold, the IRS must be notified with a tax return for the year the property was sold in. This is the case even if we do not anticipate any taxes owed because we received a step up in basis. Just a simple fact that the house was sold means the IRS wants a return for you to tell them. If, however, the real property is going to be kept, then no return is needed. No bank account is needed, and thus no EIN. The property can be distributed from the trust with the grant deed recorded at the county recorder's office, and it doesn't matter to the IRS. The county assessor, though, they're going to want their pound of flesh, but that's a topic for its own lengthy discussion. But with that, that still leaves us two scenarios where an EIN may be required. The first is where we have a trust where the trustor, the one who made it, is incapacitated. They lacked the testamentary capacity to be able to make an amendment to the trust, but they're still alive. What do we do in that scenario? Well, yes, in that case, at that point in time, the trust would be considered irrevocable. No changes can be made, and typically an irrevocable trust is seen as its own entity and thus files its own tax return. In this case, where we have someone who created their own trust and then later loses capacity, they are still going to be tied to that trust personally, and the assets in that trust still likely going to be tied to them. So all that means is that even if they can no longer be a trustee because they lack capacity, the assets in that trust are still their assets. So any activity in which they earn money and which taxes would be owed is still tied to them personally. So with that, even if they can't be a trustee, we would still be able to use their social security number in order to have a trust bank account open. At that point, we're typically just going to have somebody else, a successor trustee, who's going to step in and be managing all the trust assets, and it's usually the same person who may also be listed on powers of attorney. So with that, that person would be able to file a tax return on that person's behalf with the IRS and also be able to manage all the funds, whether in their personal estate or in their trust estate. And everything is still tied to that person's social security number. It's not until after they pass away that we then will need a new EIN for the trust. And the other instance where we'll likely need an EIN for a trust is for an irrevocable trust. Now, I know I just said not all irrevocable trusts, just by the nature of being irrevocable, means they need an EIN, but in this case, this is a trust that is created irrevocable from the start for an intended purpose. An example of this would be a special needs trust. We're creating a trust to hold assets for the benefit of some third party with special needs. We're putting somebody else as the trustee, usually a well child or a trusted family member. And we, as the parents or grandparents or whoever, are the ones creating the trust in the first place. Now that trust is its own entity, like a corporation, like an LLC. It owns its own assets. It's separate from me, it's separate from the trustee, it's separate from the beneficiary, and that's by design, to make it its own entity so that that beneficiary can qualify for some sort of public assistance, but those assets are not theirs and thus would disqualify them for that assistance. In that case, that trust is now its own entity. So it needs an EIN in order to open up a bank account and start using money to help supplement or care for the beneficiary. Now, even if we get an EIN, doesn't mean we need to run around and open up the trust bank account right away. Oftentimes, a special needs trust will be set up, but it's not funded. Money isn't put into it until after the person who made the trust in the first place has passed away. So in most cases, mom and dad will create a trust, and then they'll also create a special needs trust for one of their children in particular. They'll put one of their other children as the trustee of that special needs trust. Everything's going to be signed and put in place now, but nothing goes into that trust until after both mom and dad have passed away. Then that special needs trust becomes a beneficiary of their normal revocable living trust. At that point, that special needs trust gets funded, trust bank account is open, money's put into that account, and that special needs trust files its own tax return from that point onwards. Now, keep in mind, I know I said special needs trust a whole bunch of times and use this as an example of somebody with special needs, but it doesn't have to be only for someone with special needs. Typically, we're setting up that sort of a trust in order to just take care of somebody who, for whatever reason, can't have a bunch of assets in their name alone. But with that, I won't keep you any longer. So what did you think? Did you learn something? Need me to expand on anything related to what we discussed today, or have another topic you want me to discuss? Today's video is a direct response to a recent comment on my channel, so I do read your comments. So let me know down in those comments below. I'm attorney Andrew Bethel, and I'll see you at our next meeting.